Before we begin, please note that the information provided in this video is for general informational and educational purposes only and does not constitute legal advice. I am not an attorney, and watching this presentation does not create an attorney-client relationship. The law varies significantly by state and your individual circumstances. You should always consult with a licensed attorney in your jurisdiction for advice on your specific legal issue. You get a certified letter in the mail. Your heart sinks. It's from your former business partner, and it's filled with dense, threatening legal jargon you don't understand. Or maybe it's a notice from the IRS, or a letter from your landlord that basically says, pay an insane amount of money or you're out. That cold knot of panic tightens in your stomach. Your first thought isn't, let me call my lawyer. For most of us it's, oh my God, how much is a lawyer going to cost? That single question is a brick wall. It stops millions of Americans dead in their tracks every single year. We know we need help. We know we're in over our heads. But the fear of a $500 an hour bill, of a $5,000 retainer we just don't have, is paralyzing. So we do nothing. We hope the problem goes away. And we all know how that usually ends. But what if there was another way? What if you could get real professional legal guidance on your specific problem from a licensed attorney for less than the cost of a fancy dinner? In the last few years, a quiet revolution has been happening in the legal world, fueled by technology. I'm talking about online lawyer consultations. You've probably seen the ads. Websites promising to connect you with a lawyer in minutes. Flat fee consultations for $100, maybe $200. Sounds almost too good to be true. And that's the big question, isn't it? Is it a scam? Is it just a bait and switch to get you on the hook for bigger fees? Or is it the single most powerful, cost-effective tool you can use to protect yourself when you're facing a legal storm? This video is going to answer that question once and for all. We're going to cut through all the marketing hype and the lawyer speak to give you the unvarnished truth. We will break down exactly what an online legal consultation is, and more importantly, what it isn't. You will learn the 3 types of legal problems where an online consultation can be a brilliant, money-saving first step, and the 2 critical situations where using one could be a catastrophic mistake. By the end of this video, you won't just have an opinion. You will have a clear, practical framework. You'll know exactly how to vet these services, what questions to ask, and how to walk away from that initial consultation with a concrete action plan, all without breaking the bank. This isn't just about saving a few $100s. This is about taking control, erasing that paralyzing fear of the unknown, and making an informed, powerful decision about your future. So let's get into it. First, let's dismantle the old way. The way things have been done for 100 years. Imagine this, you have a problem. Maybe it's a dispute with a landlord who won't return your security deposit. Or maybe you're starting a small business, a passion project, and you're terrified of getting the paperwork wrong. That knot forms in your stomach. You know you need legal advice, but the thought of it is just heavy. So you go to Google. You type in lawyer near me, and you're hit with a wall of websites. They all look the same. Slick, corporate, with photos of serious-looking people in power suits standing in front of shelves of identical leather-bound books. There are no prices, not a single dollar sign. Instead, you see vague promises like aggressive representation and decades of experience. You take a deep breath and pick one. You call the number. A gatekeeper, a receptionist, answers. You try to explain your situation, feeling a little embarrassed, a little small. You ask the one question you really care about. How much would it cost to just talk to someone about this? And you get the classic soul-crushing answer. Well, the attorney's hourly rate is $400, but I can't tell you how long it will take. You'll have to book a consultation. The consultation itself might be free, or it might be $150 just to walk in the door. You don't know. You have to take time off work, drive downtown, pay for parking, and walk into a lobby that feels designed to intimidate you. Marble floors, expensive art, and unnerving quiet. You sit there, your heart pounding, rehearsing your story, terrified you'll forget a key detail or sound foolish. Finally, you're led into the inner sanctum. The big office, the mahogany desk, the view of the city. And as you sit there trying to explain the nuances of your landlord dispute or your business idea, you can't shake one single terrifying thought. The clock is ticking. Every minute I'm talking is costing me money. A lot of money. You rush through your story. The lawyer might be great, or they might be distracted checking their email. They use jargon you don't understand, tortious interference, indemnification clause, statute of limitations. You nod along pretending you get it, because you're too intimidated to ask them to slow down and explain it in plain English. You walk out an hour later with a folder of papers and a vague sense of what to do next. A week later, a bill arrives in the mail. It's for $700, and you're still not entirely sure what your next move is. You just know it's going to cost even more. For millions of Americans, this is the reality of getting legal help. So expensive, so intimidating, and so opaque that most people just give up. They abandon their business idea. They let the landlord keep the deposit. They sign the contract without reading it. They roll the dice and hope for the best, because the alternative is simply too daunting. Now let's paint a different picture. Let's imagine that same scenario in the world of online legal consultations. You have the exact same problem, the landlord, the new business. That same knot is in your stomach. But this time, your journey is different. You go to a legal marketplace website. Instead of a wall of intimidating firms, you see a grid of faces. These are individual lawyers. You see their names, their pictures. You see exactly what they specialize in: landlord-tenant disputes, small business formation, contract review. And right there, next to their face, is the magic number. The price. Not a vague hourly rate, but a flat fee. 30-minute video consultation, $79. Contract review and consultation, $199. Business formation strategy session, $250. It's all there. The transparency is breathtaking. There are no gatekeepers. There are no hidden fees. The price is the price. But it gets better. You can see their reviews. Not curated testimonials on their own website, but real unfiltered reviews from hundreds of people just like you. Sarah was amazing. She explained my lease options in a way I could finally understand. Mark helped me choose between an LLC and an S-Corp in 20 minutes. Best money I ever spent. You're not flying blind anymore. You're using the power of the modern internet, crowdsourced wisdom, to choose your expert. You find a lawyer who looks friendly, has stellar reviews, and specializes in exactly what you need. You look at their calendar online. You see they have an opening tomorrow at 2:30 p.m., right during your lunch break. You don't have to take a half day off work. You don't have to find a babysitter. You don't have to drive anywhere. You click book, enter your credit card information, and it's done. The total cost is exactly what they said it would be. The next day, a few minutes before 2:30, you get an email with a video link. You click it, and you're in a virtual waiting room. At exactly 2:30, the lawyer's face pops up on your screen. They're in their home office or maybe a co-working space. They're professional, but they're also a real person. They smile. Hi, thanks for booking. I've read the notes you submitted. Let's dive right in. You have 30 minutes, and my goal is to make sure you walk away with a clear action plan. Let's start with your biggest concern. There's no power play. There's no giant mahogany desk between you. It's just two people talking on a screen. You share your documents right on the screen. The lawyer marks them up in real time, highlighting the clauses that matter. They explain the legal jargon in simple, direct language. This part here, the indemnification clause, all that means is if you get sued because of the work you did for them, they won't help you. We need to change that. Because it's a flat fee for a set amount of time, the entire incentive structure is different. The lawyer is motivated to be as efficient and as valuable as possible in the time allotted. They aren't trying to stretch the conversation to bill more hours. They're trying to solve your problem and earn a 5-star review. You get to the end of the 30 minutes and you feel light. The knot in your stomach is gone. It's been replaced by clarity. You have a list of 3 specific, actionable things you need to do next. You know your rights. You know your options. You end the call and that's it. There's no surprise bill coming in the mail. There's no lingering uncertainty. You paid $80 and, in exchange, you bought peace of mind. You bought a roadmap. You transformed a paralyzing, amorphous legal fear into a simple, manageable to-do list. This is the fundamental promise of online legal consultations. It's a complete paradigm shift. It takes a system that was built on exclusivity, opacity, and intimidation, and it flips it on its head. It democratizes access to legal expertise. It makes it a consumer product like buying anything else online, where you can compare prices, read reviews, and make a purchase with confidence, all from your kitchen table. It's about shifting the power from the old guard institutions back to you, the individual. It allows you to tackle problems when they are small, before they spiral into massive, life-altering catastrophes. But, and this is a very, very big but, is it really that simple? Is this new way, this convenient, affordable digital solution, truly a perfect replacement for the old way? Or are there hidden traps? Are you sacrificing something critical for that convenience? What are the risks of putting your trust, your business, your future, into a face on a screen you've never met? Are there certain legal problems, certain situations where using an online service is not just a bad idea, but is actually dangerous? Because the answer to that is a definitive, resounding yes. And knowing when to use this amazing new tool, and when to absolutely under no circumstances go near it, is the most important thing we need to talk about next. The danger lies in a simple, seductive illusion. The idea that all legal problems are created equal. They are not. A legal issue isn't just a problem, like a leaky faucet or a dead car battery. It's a living, breathing conflict that can be as simple as a paper cut or as complex and life-threatening as a cancer diagnosis. Using the same tool for both is not just inefficient, it's malpractice. So let's draw some bright, clear lines in the sand. Let's separate the legal paper cuts from the life-altering tumors. We're going to break this down into 3 zones. The green light zone, where online consultations are a fantastic tool. The yellow light zone, where you must proceed with extreme caution. And the red light zone, the absolute unequivocal do not enter areas where using an online-only service is like playing Russian roulette with your future. Let's start with the green light zone. This is where online legal services truly shine. These are situations that are typically low stakes, informational, or preventative in nature. Think of it as legal maintenance, not legal emergency surgery. The first, and maybe the most common, use case is for simple document review. Let's imagine a woman named Chloe. She's an incredibly talented graphic designer who decides to finally turn her side hustle into a full-time freelance business. She's setting up her website, but she gets stuck on the client agreement part. She downloads a generic template from the internet, but it's filled with confusing jargon. Does it actually protect her? What if a client in California hires her, but she lives in Ohio? Whose laws apply? In the old world, Chloe's options were grim. She could call local law firms, get quoted a $500 an hour rate, and be asked for a $2,000 retainer just to look at her 3-page document. It's intimidating. It's expensive. So she'd probably just cross her fingers and use the free template, hoping for the best. But in the new world, Chloe can go onto a reputable online legal platform, find a business lawyer licensed in Ohio, upload her document, and book a 30-minute video consultation for, say, $75. In that call, the lawyer can screen share, walk her through the confusing clauses, suggest specific changes to protect her from non-paying clients, and clarify the interstate commerce question. In less than an hour, for less than the cost of a nice dinner, Chloe gets peace of mind in a professional, customized contract that protects her new business. That is a massive win. This is the green light zone in action. It's for LLC operating agreements, simple lease reviews for a rental property, or reviewing a basic employment offer. The stakes are contained, the task is defined, and the value is immense. The second green light scenario is what I call directional guidance. This is for those "can I even do this?" or "what are my options?" questions. Let's take another example. Mike and his wife live in Denver, and they want to build a small deck on the back of their house. Their neighbor, a grumpy guy named Gary, has already made comments about how it might block his afternoon sun. Before Mike spends a dime on lumber, he has a simple question. How close to Gary's property line can I legally build? A quick Google search gives him a dozen different answers, forum posts from 2012, and a link to a dense, unreadable municipal code. It's useless. So Mike spends $50 for a 20-minute phone call with a local real estate attorney he finds online. He explains the situation. The lawyer, who deals with Denver zoning laws every single day, immediately tells him about the city's specific setback requirements, explains what an easement is, and even gives him a tip on how to properly document his project with the city to prevent any future legal headaches from Gary. Mike gets a definitive, actionable answer specific to his city in minutes. He hasn't hired a lawyer to fight a war. He's paid a small fee for a map to avoid the war in the first place. That is an incredibly powerful and previously inaccessible tool for the average person. The third green light area is for an initial case assessment. This is a big one. You think you might have a legal problem, but you're not sure if it's worth pursuing. Let's say you were in a minor car accident. The other driver was clearly at fault, but their insurance is lowballing you on the repair costs. Your neck is a little sore, but you don't think it's a major injury. Is it worth hiring a personal injury lawyer and starting a lawsuit? A 1-hour flat-fee online consultation is the perfect tool for this. You can lay out the facts to an experienced lawyer, who can then give you a brutally honest assessment. They might say, look, based on these numbers and the fact that you weren't seriously injured after my fees, you'll likely walk away with very little. Your best bet is to keep negotiating with the insurance company yourself. Or they might spot a detail you missed and say, actually, the fact that this happened in a commercial zone changes things. I think you have a much stronger case than you realize. This consultation acts as a low-cost legal triage. It helps you decide whether to escalate a situation or let it go, without having to commit to thousands of dollars in retainers up front. It's about making an informed decision, and that's always a green light. So, simple document reviews, directional guidance, and initial case assessments. These are the slam dunks for online legal consultations. They are convenient, affordable, and provide targeted value. But what happens when the problem isn't a simple document? What happens when it's not just a question but a conflict? What happens when emotions, relationships, and significant amounts of money get involved? This is where we leave the bright, sunny, well-paved roads of the green light zone and enter the foggy, treacherous territory of the yellow light zone. This is where convenience can quickly become a catastrophic liability. The yellow light zone covers issues that are more complex, emotionally charged, and have the potential to escalate into a full-blown legal battle. These are situations where you might start with an online consultation to get your bearings, but you should be extremely hesitant to use an online-only lawyer for the entire matter. The number one example of this is family law. Things like divorce or child custody disputes. On the surface, it seems plausible. You find a lawyer online who offers a flat-fee uncontested divorce package. Sounds simple. Sounds cheap. But divorce is rarely simple, and it's almost never emotionally cheap. What starts as uncontested can turn ugly in a heartbeat. One spouse suddenly decides they want the house. An argument erupts over who gets the dog. A disagreement about the kid's visitation schedule becomes a war. Suddenly, you don't need a document preparer. You need an advocate. You need a strategist. You need someone who can go to court for you on an emergency basis. That online lawyer who lives 3 states away? They can't show up to your local courthouse. They don't know the specific procedures of your local family court. More importantly, they don't know the judges. Every judge has their own temperament, their own leanings, their own pet peeves. A good local family lawyer knows that Judge Smith is a stickler for financial disclosures, or that Judge Garcia prioritizes joint custody arrangements. That local, on-the-ground intelligence is invaluable, and it's something an out-of-state, online-only lawyer can never provide. They are a phantom voice on a video call, when what you really need is a warrior standing next to you in the courtroom. Another classic yellow light case is a serious business dispute. Let's say you and your business partner have a major falling out. It's no longer a simple contract question. It's about accusations of mismanagement, disputes over funds, and a battle for control of the company you built together. This is a high-stakes, dynamic conflict. It requires negotiation, mediation, and potentially litigation. You need a lawyer who can sit across the table from your partner and their attorney and read the room. You need someone who can represent you in a tense, multi-hour mediation session. An online lawyer is at a massive disadvantage here. They can't build a rapport with the mediator. They can't see the subtle body language cues. They can't pull you aside for a quick, private hallway conversation to discuss a new offer. The entire process becomes sterile and disconnected. It's like trying to perform surgery with clumsy robot arms from 1,000 miles away. You might be able to do it, but you're giving up all the nuance and skill that comes from being physically present. Think of it this way. The green light zone is for getting a diagnosis from a specialist at a top-tier clinic via telehealth. The yellow light zone is when that specialist tells you, you need a complex procedure, and you need to come in and have it done by a local surgical team who will be with you through the operation and the recovery. Using an online-only service for a complex, evolving dispute is like asking the telehealth doctor to also perform the surgery remotely. It's the wrong tool for the job, and the risks of complications are incredibly high. But even these yellow light situations where you have to be overwhelmingly cautious are nothing compared to the red light zones. These are the legal minefields where using an online-only service isn't just a bad idea. It's an act of pure self-sabotage that can irrevocably damage your finances, your freedom, and your life. And that is exactly where we're going next. So let's step into the first red light zone, the one where the flashing lights and sirens should be deafening. Criminal charges. This isn't just about a speeding ticket. I'm talking about anything that could land you with a criminal record. A DUI, a charge of possession, assault, theft, fraud. If the words "you have the right to remain silent" have been spoken to you, you are in a 5-alarm legal fire. And a web form is not a fire extinguisher. It's a bucket of gasoline. Here's why. The American justice system isn't one monolithic entity. It's a patchwork quilt of thousands of local jurisdictions, each with its own unwritten rules, its own culture, and its own key players. Your local criminal defense attorney doesn't just know the law, they know the landscape. They know that a certain prosecutor is willing to deal on a first offense DUI, but another one in the next county oversees it as a personal crusade. They know that Judge Reynolds is lenient with young offenders who show remorse, but Judge Miller will throw the book at anyone who looks her in the eye the wrong way. An online lawyer from 3 states away has zero access to this critical intelligence. They can read the same statute book you can, but they can't read the room. Imagine this scenario. Let's call him Mark. Mark gets pulled over after 2 beers at a friend's barbecue. He's just over the legal limit. He's scared, embarrassed, and wants to make it go away as cheaply as possible. He finds an online legal service that promises to handle his DUI for a flat fee of $700. Seems like a bargain. The service assigns him a lawyer based in another state who gives him a checklist. Demand the calibration records for the breathalyzer, question the officer's probable cause for the stop, file a motion to suppress. It's all technically correct, textbook legal advice. So Mark's out-of-state lawyer files these generic motions. But here's what they don't know. They don't know that in Mark's specific county, the district attorney's office has a special program for first-time offenders like Mark. It's an unwritten policy. If you plead guilty early, agree to an alcohol education class and a few months of probation, they'll reduce the charge to a lesser offense, like reckless driving. It saves your license, keeps the DUI off your record, and prevents your insurance from skyrocketing. Every local lawyer knows about this program. It's Plan A. But because Mark's online lawyer came in with guns blazing, filing aggressive motions from a template, the prosecutor gets annoyed. The informal offer is off the table. Now it's a fight. Mark's case drags on for months. The generic motions fail because they almost always do. He ends up with a full DUI conviction, a suspended license, a criminal record that will follow him for life, and thousands of dollars in fines and increased insurance premiums. He saved a few $100s on legal fees, but he paid for it with his future. A local lawyer would have cost more upfront but would have saved him from the one thing that truly matters, the conviction. In criminal law, local knowledge isn't a bonus. It's everything. The second red light zone is high-stakes family law. I'm talking about the legal battles that define the rest of your life, contentious divorces, and most critically, child custody disputes. When you are fighting for the right to raise your own child, the idea of entrusting that to a faceless online service should be terrifying. Family law is intensely personal and emotionally charged. The person guiding you through it needs to be more than just a legal technician. They need to be a strategist, a counselor, and a fierce advocate who understands the human element. They need to look a judge in the eye and make a compelling case for why you are the parent your child needs. And just like criminal law, it is hyper-localized. Child custody guidelines can vary dramatically from state to state, and even from judge to judge within the same courthouse. One judge might prioritize keeping siblings together at all costs, while another might be a huge proponent of a 50-50 split unless there's a compelling reason otherwise. Let's talk about Sarah. She's trying to get primary custody of her 2 kids during a difficult divorce. Her ex-husband has a high-powered, expensive local attorney. Sarah, trying to conserve money, uses an online document preparation service to file her custody motion. The service helps her fill out standardized forms. It all looks official, but the service doesn't know that the presiding judge in her family court, Judge Thompson, is a stickler for details. He has a specific, unwritten preference for how financial affidavits are organized and how parenting plans are detailed. He wants to see a minute-by-minute plan for holidays and summer vacations. Sarah's standardized forms are legally sufficient, but they aren't what Judge Thompson wants to see. When her case comes up, the judge is immediately irritated. He sees her paperwork as sloppy and incomplete. It creates a first impression that she is disorganized and not taking this process seriously. Her ex-husband's lawyer, who has appeared before Judge Thompson 100 times, presents a binder with everything formatted exactly to the judge's preference. From that moment on, Sarah's fighting an uphill battle. The judge's perception of her is already tainted. The online service helped her file a document, It couldn't help her win the judge. She saved $1,000, but that initial negative impression cascaded through every subsequent hearing, ultimately contributing to a custody arrangement that was far from what she had hoped for. In a custody battle, you're not just arguing the law, you're making a case for your character. You need a local guide who knows the person who will be making that final life-altering decision. The third, and perhaps most financially devastating red light zone, is a serious personal injury claim. If you've been severely injured in a car wreck, a slip and fall, or due to medical negligence, your entire future, your ability to work, your quality of life, your financial stability, hangs in the balance. On the other side of the table is an insurance company, a multi-billion-dollar corporation with entire departments of experienced lawyers and adjusters whose single solitary job is to pay you as little as possible. Using an online legal service in this situation is like showing up to a heavyweight prize fight with a pool noodle. You're going to get destroyed. Here's the crucial thing most people don't realize about personal injury law. The vast majority of reputable, experienced local attorneys work on a contingency fee. This means they only get paid if you get paid. They take a percentage of the settlement or verdict. There is no upfront cost to you, so the entire argument for using a cheap online service to save money is completely irrelevant. You can get a legal gladiator, a top-tier local expert, for literally $0 out of your pocket. Consider the story of David. He was rear-ended by a truck and suffered 2 herniated discs in his back. The pain is chronic. He can't work his construction job anymore. The insurance company offers him a quick settlement of $75,000. Sounds like a lot of money. David is worried about legal fees, so he pays $500 to an online service to have a lawyer review the offer. The out-of-state lawyer plugs the numbers into a software program, looks at national averages, and tells David the offer is reasonable, and he should probably take it. Thank God he didn't. His brother convinced him to at least talk to a local personal injury specialist. The local lawyer meets with him for free. He doesn't look at a database. He looks at David. He listens to his story. Then he gets to work. He hires a local medical expert to detail the long-term costs of David's back injury, future surgeries, physical therapy, a lifetime of pain management. He hires an economist to calculate David's lost future earnings from his construction career. He knows what local juries in their specific county have awarded for similar injuries. He knows the insurance company's local lawyers, knows their tactics, and they know he is not afraid to take a case to trial and win. After months of aggressive negotiation, backed by expert reports and the credible threat of a lawsuit in their hometown court, the insurance company settles. The final amount isn't $75,000. It's $1.2 million. The online service would have cost David over $1 million. In a personal injury case, a local lawyer isn't a cost. They are an investment that pays for itself many, many times over. They don't just know the law. They know the value of your pain in the one place it matters, your local courthouse. These red light zones, criminal defense, high-stakes family law, and serious personal injury, are the absolute non-negotiables. They are the areas where the complexity of the law is matched only by the severity of the consequences. They require a human touch, local expertise, and a strategic mind that a piece of software or a remote, disconnected attorney simply cannot provide. Trying to navigate these minefields with a budget online service isn't just a risk, it's a guaranteed loss. But this doesn't mean all online legal help is a trap. The key is knowing what tool to use for which job. And to do that, we need to understand the fundamental difference in what these services are actually selling you, which is often not what you think. The fundamental misunderstanding that costs people fortunes and sometimes their freedom is the confusion between two very different products: legal information and legal advice. They sound similar. They often look similar. But confusing them is like confusing a cookbook with a Michelin star chef. One gives you the ingredients. The other creates a masterpiece tailored to your exact tastes. Let's start with legal information. This is the vast majority of what you find online. It's every blog post titled, "What to Do After a Car Accident." It's every template for a last will and testament on a DIY legal website. It's every YouTube video explaining the difference between an LLC and an S-Corp. Legal information is generic. It's educational. It is a one-to-many communication. The goal of legal information is to describe the law in broad strokes. It can tell you what the speed limit is on a highway. It can explain the general process for filing a small claims court case. It's often accurate, and it can be incredibly useful for getting a basic understanding of a topic. But here is the critical, non-negotiable truth. Legal information is not about you. It cannot be. It doesn't know the specific facts of your case. It doesn't know that when you were in that car accident the other driver was texting, but you were also going 5 miles over the speed limit. It doesn't know that your will needs to account for a child with special needs, or that your business partner has a history of financial trouble. Because it doesn't know your story, it can't apply the law to your unique circumstances. This is why every reputable source of legal information, from major legal websites to a lawyer's blog, will have a disclaimer somewhere that says, "This is for informational purposes only and does not constitute legal advice." That's not just boilerplate text. It is a bright red warning sign. They are legally and ethically telling you, this is a map of the territory, but we are not your guide. You are walking through this minefield alone. Now let's talk about legal advice. This is the Michelin star chef. Legal advice is the application of legal rules and principles to a specific set of facts. It is a one-to-one communication. It can only happen within the protected bubble of an attorney-client relationship. When you receive legal advice, a lawyer is doing 3 things that a website or a template can never do. First, they are listening to your specific, messy human story and filtering it through their years of training and experience. They are spotting the legally significant details that you might think are irrelevant. That offhand comment you made about your boss's email? That might be the smoking gun in an employment case. The fact that you paid for the home renovations with your inheritance? That could completely change a divorce settlement. They take your unique facts and connect them to the relevant laws, statutes, and previous court decisions. Second, they are providing you with a strategic analysis of your options, including the risks and potential outcomes. Legal advice isn't just "the law says X." It's "the law says X, and given your situation, that means you have a 70% chance of success if we go this route. However, it will cost this much and take this long. If we go route B, your chances are lower, but it will be faster and cheaper. And you need to be aware that if we do either, your opponent will likely do Z, and we need to be prepared for that. It's a strategic roadmap, not just a map of the country. It anticipates problems you don't even know exist. And third, legal advice gives you a recommended course of action. It's a clear directive. Do not sign that severance agreement. Send this specific certified letter immediately. We need to file this motion before the deadline on Friday. It's an expert telling you what to do, what not to do, and why. This is the opposite of generic information. It is a bespoke, actionable plan built exclusively for you. Let me tell you a quick story about a guy we'll call David. David wanted to start a small consulting business with his friend Mike. He was smart and resourceful, so he went online. He read dozens of articles and watched hours of videos about setting up a business. He learned all about LLCs. He went to a popular legal template website and paid a small fee for an attorney-approved LLC operating agreement. He filled in the blanks, his name, Mike's name, the business name, and felt a huge sense of accomplishment. He'd saved thousands on legal fees. He'd gotten all the legal information he needed. For 2 years, things were great. The business grew. But then, David and Mike had a major disagreement about the future of the company. It was bitter and personal. Mike decided he wanted out and he wanted to be bought out. David pulled out their operating agreement, the one he'd so proudly downloaded. He scrolled down to the section on buyouts. His blood ran cold. The generic one-size-fits-all clause in the template stated that a departing partner must be bought out based on the book value of the company, not its fair market value. Because they had reinvested all their profits, the company's book value was incredibly low. But its actual market value, based on its client contracts and goodwill, was 10 times higher. The template clause, which was perfectly legal and technically correct, was about to force David to either sell the company or give his former friend a massive unearned windfall. The articles he read had mentioned buyout clauses, but they couldn't give him advice. They couldn't ask him, "David, what's your relationship with Mike like? Do you trust him completely? What happens if you disagree? Should we put in a clause that triggers a third-party valuation to protect you both?" A 30-minute consultation with a real lawyer would have included those questions. That lawyer would have advised him to insert a specific clause tailored to his situation, potentially saving him a 6-figure catastrophe. David learned the hard way that the most expensive legal help you can get is the free or cheap information you mistake for advice. He ended up hiring a lawyer anyway, spending tens of thousands of dollars to clean up a mess that a 1-hour, $400 consultation could have prevented entirely. This is the core of the issue. A true online lawyer consultation, the kind we're analyzing, is not just another source of legal information. It is the portal through which you access actual legal advice. It's the moment you stop looking at a generic map and hire an expert guide who knows the terrain, can see the storm clouds gathering on the horizon, and can lead you safely to your destination. It's the conversion of public data into private, protected, and personalized strategy. So, we've established the what, the critical game-changing difference between information and advice. But that unlocks the even more important question, the when. When is a 30-minute video call with a lawyer a brilliant, cost-effective move? And when is it a catastrophic mistake that could jeopardize your entire case? To answer that, we need to break down the 3 distinct categories of legal problems, and one of them is an absolute minefield for online-only consultations. The first category is what I call the transactional. Think of this as the legal equivalent of building a piece of furniture from IKEA. You have a clear goal: draft a will, form an LLC, review a freelance contract, or handle a simple real estate closing. The process is guided by a set of instructions, the law, and it primarily involves assembling the right pieces, which are your documents and information. In this scenario, an online lawyer is not just a good option. They are often the best option. Why? 3 reasons: efficiency, cost, and access to specialization. Let's bring this to life with Sarah. Sarah is a brilliant web developer who just landed a dream project with a major tech company. It's the kind of client that could change her career. Along with the excitement, she gets a 22-page independent contractor agreement. It's an impenetrable fortress of legalese. Words like indemnification, work for hire, and covenant not to compete jump out at her. She has this gut-wrenching fear that buried in paragraph 17 subsection D is a clause that says she owes them her firstborn child if she's a day late on a deadline. Her local options are daunting. The lawyers in the fancy downtown offices charge $400 an hour, with a 3-hour minimum. That's $1,200 she really can't afford to spend just to understand a contract. So she hesitates, staring at the signature line, tempted to just sign it and pray. Instead, she finds a legal tech platform that offers flat-fee contract reviews. For $350, she uploads the document. 2 days later, she's on a video call with a lawyer named David who lives 3 states away but specializes exclusively in tech contracts for creatives. He doesn't just practice this law, he lives and breathes it. In 30 minutes, David surgically dissects the contract. He says, "Sarah, 90% of this is standard. But see this work for hire clause? The way it's written, they could claim ownership over the side project app you've been building on your own time. That's a non-starter." He then points to the non-compete clause. This says you can't work for any other software company in North America for 2 years. That's completely unenforceable in your state, but they put it in there to scare you. David doesn't just identify the problems, he gives her the solution. He drafts 2 simple, non-confrontational paragraphs for her to email to the client, suggesting specific revisions. Sarah sends the email. The client's legal department agrees to the changes without a fuss. They were just using their standard, overly aggressive template. Sarah signs the revised contract with total confidence. The online consultation didn't just save her nearly $1,000. It protected her entire future career from a catastrophic mistake. For a transactional issue, it was the perfect tool for the job. But what happens when you're not just building something? What happens when someone is trying to knock your building down? This brings us to the second category, the adversarial initial. This is where a dispute has been born. You're not in court yet, but the battle lines are being drawn. Maybe you've received a cease and desist letter. Maybe your landlord is refusing to return your $5,000 security deposit. Or maybe you're a small business owner, and a former partner is threatening to sue, claiming you stole their idea. This isn't IKEA anymore. This is a chess match. Your opening moves will define the entire game, and one wrong step can put you in a position you can never recover from. This is where an online consultation becomes a yellow light. It can be incredibly valuable, but it's also fraught with hidden dangers. Let's look at Mark. Mark poured his life savings into opening the Daily Grind, a beloved neighborhood coffee shop. One morning, he gets a terrifying letter via certified mail. It's from Aroma Coffee Company, a massive, soulless national chain. They claim his logo, a simple coffee bean with a swirl of steam, is a trademark infringement on their logo. They demand he cease all operations, destroy all his branding, and rebrand his entire business within 30 days or face a federal lawsuit that will bankrupt him. Mark is in a full-blown panic. He jumps online and finds a service offering a 1-hour video consultation with an intellectual property lawyer for $200. The lawyer is smart. He's professional. He pulls up both logos on his screen, listens to Mark's frantic story, and gives him a textbook-perfect explanation of trademark law. He explains the likelihood of confusion standard and tells Mark that while their case is aggressive, it's not frivolous. He says Mark could fight it, but it would be expensive, and going up against a corporate giant is always risky. Mark hangs up the call feeling informed, but also hopeless. The lawyer gave him the facts of the law, the what, but he didn't give him a path forward. Defeated, Mark mentions it to a customer, who insists he talk to her friend, a local business litigator named a few blocks away. Mark reluctantly agrees. He walks into her office, a cluttered room filled with books, not a sterile virtual background. The first thing she asks isn't about the logo. She asks, "Mark, tell me about your neighborhood. Who are your customers? How long have you been here?" She listens intently. Then she leans forward and says something the online lawyer could never have known. "The law firm that sent this letter? I know them. I've dealt with their lead partner Johnson on 3 different cases. He's a bulldog, but he's also bluffing 90% of the time. Their business model is to send out 100 of these hyper-aggressive letters hoping 95 people will just roll over without a fight. They don't have the time or resources to actually sue every little coffee shop in America." She saw something the online lawyer couldn't: the local context, the human element. She understood the opponent's strategy, not just their legal argument. She drafted a response that was polite, legally sound, but also subtly called their bluff, highlighting Mark's deep community ties and the lack of any actual customer confusion. 2 weeks later, Mark got a short letter back stating that Aroma Coffee Company had decided not to pursue the matter at this time. The game was over. The online consult gave Mark a map of the chessboard. The local lawyer told him how the other player liked to cheat. So we've seen where online consults are a perfect fit for transactional work, and where they function as a risky but potentially useful first step for initial disputes. But there's a third category. This is the minefield I warned you about. This is the one where relying solely on a face on a screen isn't just a strategic error. It can be a life-altering catastrophe. This is the world of high-conflict litigation, where the truth isn't just in the documents. It's in the tremor in a person's voice, the sweat on their brow, and the story that can only be told eye to eye. And that's where we're going next. Imagine a lawyer's office. Not the one you see on TV, all mahogany and leather-bound books. A real one, a bit cluttered, smells faintly of coffee and paper. A man, let's call him David, sits across the desk. He's here for a consultation about a bitter business dispute with his lifelong friend and partner, Michael. Online, David's emails were impeccable. He was articulate, organized, and laid out a timeline of events that painted Michael as a treacherous, greedy villain who was trying to steal the company they built from the ground up. On their initial video call, David was calm, collected, and sympathetic. He looked like the perfect client, the clear victim. Any lawyer would be chomping at the bit to sign him. But this lawyer, a veteran of partnership dissolutions, had a rule. For cases like this, the final consultation before signing a retainer had to be in person. No exceptions. And now David is in the room. The lawyer starts by asking the same questions from the video call. But this time he's not just listening to the words. He's watching. He asks David to walk him through the day he discovered Michael's alleged betrayal. As David starts talking, the lawyer notices it. A slight, almost imperceptible tightening in his jaw. His hands, which were resting calmly on his lap, are now lightly clenched. The lawyer leans forward. "David, you said Michael locked you out of the company accounts. Tell me exactly how you found out." David recounts the story, his voice steady. But his right foot starts tapping. A quiet, rhythmic beat against the floor. Tap, tap, tap. It's the only thing in the room that seems agitated. The lawyer makes a note. Then he shifts gears. "Tell me about the early days. When you and Michael started the company in your garage. What was that like?" A flicker of something crosses David's face. It's not nostalgia. Something harder. He talks about their shared dream, but his language is all about his sacrifice, his late nights, his brilliant ideas. Michael becomes a supporting character in David's own hero story. The lawyer then asks the critical question, the one he saved for this moment. "There's a 3-week gap in your email records from last April. Michael's lawyer is going to ask about it. What happened then?" The tapping stops. The room is silent. David looks at the lawyer, and for the first time the calm, collected mask slips. A flash of anger, hot and real, appears in his eyes. He says, "That's irrelevant. It has nothing to do with him stealing from me." But the lawyer knows. That 3-week gap is everything. It's the key that unlocks the entire case. The tremor in David's voice, the sudden defensiveness, the angry glint in his eye. None of this came through a webcam. A webcam would have shown a man pausing to think. The room, the physical space, showed a man with a secret. A man whose story had a giant gaping hole he was desperately trying to hide. This is the art of reading people. It's a skill that seasoned lawyers develop over thousands of hours of face-to-face interaction. It's the understanding that what isn't said is often more important than what is. It's the ability to sense deception, not through a polygraph, but through the dozens of micro-expressions, postural shifts, and tonal variations that we all exhibit when we're under pressure. A video call, as good as the technology gets, is a filtered reality. It flattens a 3-dimensional human being into a 2-dimensional image. It smooths over the awkward silences, it hides the nervous energy, it masks the scent of fear or the subtle arrogance in a person's posture. In a high-conflict divorce, a lawyer needs to know if the client claiming to be a victim is actually a master manipulator. They need to see how that person's eyes change when they talk about their children versus when they talk about the marital assets. Is there genuine pain or is there a cold, calculating glint? That distinction, which can be the difference between winning and losing custody, is incredibly difficult to parse through a pixelated screen. Think about a criminal defense case. A client swears they are innocent. Their story sounds plausible on the phone. But in person, the lawyer can see the way they refuse to make eye contact when discussing the specific time of the crime. They can feel the palpable desperation that might cause someone to lie, even to their own counsel. The lawyer isn't just assessing the facts of the case. They are assessing the client's credibility as a potential witness. Will a jury believe this person? Will they crumble under cross-examination? The lawyer has to make a gut-level call. And that gut feeling is fed by a fire hose of sensory information that only exists when two people share the same physical space. Or consider a serious personal injury claim. The client says they have debilitating back pain and can barely walk. On a video call, they are sitting and they look convincing. But when they come to the office, does the lawyer see them bound out of their car in the parking lot? Do they walk down the hall with a fluid, easy gait, only to adopt a pained limp as they cross the threshold of the lawyer's door? It happens. And an in-person meeting is the ultimate low-tech lie detector. This isn't about lawyers being superhuman. It's about them being human. We are all wired to read other people. For millennia, our survival depended on our ability to quickly assess threat, trustworthiness, and intent in others. A lawyer in a high-stakes situation is using that same ancient software. They are running a diagnostic on you, the potential client. Are you telling the whole truth? Are you hiding something that could blow up the case later? Are your expectations realistic? Are you someone they can build a trusted, confidential relationship with for the next 2 years of grueling litigation? The lawyer-client relationship in these difficult cases is a partnership. It's a foxhole. And you don't want to be in a foxhole with someone you've only ever met on a screen. The lawyer is performing a professional vibe check. And it's one of the most important services they provide, often before you've even paid them a dime. The cost of misjudging a person in a legal context is catastrophic. If the lawyer takes on David, the business owner, without realizing he's the one with the secret, they'll build the entire case on a foundation of lies. They'll march into depositions and courtrooms completely unprepared for the bombshell that Michael's lawyer is about to drop about that 3-week gap. They will lose. And David will not only lose his company, but he will have spent tens, maybe hundreds of thousands of dollars in legal fees for a case that was doomed from the start. All because his lawyer missed the tapping foot and the angry glint in his eye. That is the hidden danger of relying solely on virtual consultations for complex, emotionally charged, and credibility-dependent legal battles. The convenience of a video call can be incredibly seductive, but in the world of high-conflict litigation, what you save in travel time, you could lose in the final judgment. The truth is not always in the documents. Sometimes it's in the room. It's in the air. You just have to be there to feel it. So for the battles that are fought in the trenches of human emotion, for the disputes where character is on trial just as much as the facts are, face-to-face is king. There is no substitute. But what about the rest? What about the 90% of legal issues that aren't courtroom dramas? The contract reviews, the uncontested filings, the straightforward business formations? Is it possible that for many of us, the future of legal help isn't in a stuffy office but right here through the screen? The answer is a resounding yes, and it's more revolutionary than you think. Let's peel back the curtain because this revolution isn't some far-off, abstract concept. It's happening right now, in the real world, to people just like you. To understand its power and its pitfalls, let me tell you about a woman named Sarah. Sarah is not a real person, but her story is a mosaic of thousands of true stories playing out across America every single day. Sarah had a dream, one baked in passion and flour. She wanted to open an online bakery. She called it Sarah's Sweet Slices. She poured her life savings into perfecting her recipes, building a website, and buying equipment. But then she hit the wall. The legal wall. She knew she needed to form an LLC to protect her personal assets, and she wanted to trademark her brand name. She called a local law firm, the one with the fancy mahogany desk and the name on the side of a downtown building. The quote she got back felt like a punch to the gut. $5,000 plus filing fees. For a business that hadn't sold a single cookie yet, that was an impossible sum. It was the kind of bill that kills a dream before it even gets a chance to breathe. Feeling defeated, Sarah did what we all do. She went online. And there she found it. A legal tech platform promising to form her LLC for a few $100. Seemed too good to be true. A scam maybe? But she read the reviews, watched the tutorials, and with a mix of desperation and hope, she clicked buy. The experience was shocking. In the best way possible. There was no jargon. No intimidating office. Just a clear step-by-step questionnaire she could fill out at midnight, covered in flour, after a 14-hour day of test baking. It asked her for her business name, her address, her members. It explained what an operating agreement was. Within an hour, her paperwork was generated, ready for filing. The platform handled the submission to the state. A few weeks later, an official document arrived in her email. Sarah's Sweet Slices LLC was real. It was official. And it cost her less than a newsstand mixer. For Sarah, this wasn't just convenience. It was the difference between her dream living and dying. Buoyed by this success, she decided to tackle the trademark using the same service. Why wouldn't she? It had worked perfectly before. The platform had a trademark registration package. It included a direct hit search of the federal database. She typed in Sarah's Sweet Slices. The system whirred for a moment and came back with a green check mark. Clear, it said. She was ecstatic. She paid the fee, filled out another simple form, and the application was filed. She felt invincible. Like she had unlocked a secret cheat code to the world of business. 6 months later, a certified letter arrived. It wasn't from the trademark office. It was from a law firm in a neighboring state. The letter was thick, heavy with legal threats. It was a cease and desist. It turned out, a well-established regional bakery chain called Sweet Slice Pies was claiming her brand name was confusingly similar and would dilute their trademark. They demanded she immediately abandon her application, shut down her website, and destroy all her branding. Panic set in. A cold, gut-wrenching panic. How could this happen? The website said her name was clear. Here's the brutal lesson Sarah learned. The platform's automated search was telling the truth, but not the whole truth. It was designed to look for an exact match. And no, there was no other registered trademark for Sarah's Sweet Slices. But trademark law is not about exact matches. It's a complex web of nuance, interpretation, and legal precedent built around a concept called likelihood of confusion. It considers the sound of the words, their meaning, the goods they represent, and the markets they serve. It's an analysis that, right now, requires a human brain. A trained, experienced legal brain. The algorithm that had so beautifully handled the straightforward black and white task of filing an LLC was completely out of its depth in the subjective gray area world of intellectual property. Sarah was back at square one, but worse. Now she wasn't just starting a business. She was defending it. The thought of hiring that $5,000 lawyer was now a terrifying necessity. But then she remembered the online platform. She went back, not to the automated forms, but to a different section she had ignored before. Talk to a lawyer. For a flat fee of a few $100s, she could book a 1-hour video consultation with a business attorney who specialized in intellectual property. She scheduled a call for the next day. A lawyer, a real person named David, appeared on her screen. He wasn't in a stuffy office. He was in a home office with a bookshelf behind him. Sarah, her voice trembling, explained the situation and forwarded him the letter. He listened patiently. He didn't judge. He didn't say, "I told you so." He just listened. Then he started talking. He pulled up the Sweet Slice Pies trademark. He explained the legal test for likelihood of confusion in plain English. He walked her through the strengths and weaknesses of her case. He told her that fighting it would be long, expensive, and uncertain. But then he gave her something else, a strategy, a path forward. He suggested a minor rebrand, something that kept the heart of her name but created legal distance. Together they brainstormed. They landed on Sarah's slice of heaven. It was different enough. David then helped her draft a formal response to the cease and desist letter. Not an aggressive counterattack, but a professional de-escalating letter that stated her intent to amend her brand name and application, avoiding a costly legal battle. The entire consultation, including the follow-up emails to review the draft, cost her less than 10% of that initial quote from the traditional firm. She had lost her first name choice, but she had saved her business. Sarah's story is the perfect microcosm of the online legal world. It's not a simple story of good versus bad. It's a lesson in using the right tool for the right job. This is the core of the revolution, the unbundling of legal services. For a century, when you hired a lawyer, you bought the whole package. You paid a huge retainer, and they handled everything at a high hourly rate, whether it was simple administrative filing or complex courtroom litigation. It was a package deal, all or nothing. Online platforms have blown that model to pieces. They've taken that expensive package and unbundled it, laying out all the pieces on a digital menu for you to choose from. You can order a la carte. You need a simple, standardized document like a basic will or an LLC formation. That's Tier 1. These are the DIY automated forms. They are fantastic for low-risk, procedural tasks where the variables are few and the law is clear-cut. They are tools like a power drill. In the right hands for the right project, they are incredibly efficient. But you wouldn't use a power drill for heart surgery. You need ongoing basic legal questions answered for your small business? That's Tier 2. These are the subscription services that give you access to a library of documents and short calls with lawyers for a flat monthly fee. It's like having a lawyer on retainer for the price of a gym membership. It's perfect for preventative care, for getting a quick gut check before you sign a small contract or hire your first employee. But what about when you get a cease and desist letter? Or when your straightforward divorce suddenly involves a custody dispute? That's when you need Tier 3, the online marketplace or virtual law firm. This is where you connect directly with a specialized attorney for a specific task, a consultation, a contract review, a strategy session. This is the hybrid model that saved Sarah's business. It combines the efficiency, cost transparency, and accessibility of a tech platform with the critical thinking, experience, and nuanced advice of a dedicated human expert. This is the true revolution. It's not about robots replacing lawyers. It's about giving you the consumer control. It's about giving you choices beyond the one-size-fits-all $5,000 package. It's the democratization of law, transforming it from an intimidating, opaque institution into a flexible, on-demand service. It allows you to be a smart, empowered client, using affordable tech for the simple stuff and strategically deploying human expertise, only when it's truly needed. We've seen how this new model can be a lifeline for a small business navigating the complexities of contracts and trademarks. But what happens when the stakes are not just financial but deeply, profoundly personal? What about the legal issues that define our lives? A divorce, a child custody battle, a criminal charge, a personal injury claim. Can a lawyer on a screen truly grasp the weight of these moments? Or in our search for convenience and savings, are we at risk of making a catastrophic mistake in the most important moments of our lives? The answer is far more complicated than a simple yes or no. It's a tightrope walk over a canyon. On one side, you have the promise of accessibility, affordability, and speed, the hallmarks of our digital age. On the other, the proven time-tested value of human connection, local expertise, and the careful, deliberate practice of law. The risk isn't just that you might get bad advice. The risk is that you might get advice that is almost right, which is infinitely more dangerous. A single subtle misinterpretation, a missed local ordinance, a failure to grasp the true emotional stakes of your situation. These are the small hinges on which giant doors of disaster swing. Let's start with the most human element, the one we instinctively understand but often discount in our quest for efficiency. The loss of the third dimension. When you sit in an office with an attorney, they aren't just listening to your words. They are observing you. They're seeing the way your hands tremble when you talk about the accident. They notice the slight hesitation before you answer a question about your business partner. They feel the tension in the room when you discuss your spouse. These aren't just vibes. This is data. For a seasoned lawyer, This nonverbal information is as critical as the documents you brought with you. It helps them gauge your credibility, understand your emotional state, and identify potential weaknesses in your case that you might not even be aware of yourself. Over a video call, so much of this is lost. The camera angle is weird. The lighting is bad. The audio cuts out for a split second right when you're making a crucial point. Is your hesitation because you're being deceptive? Or is your internet connection just lagging? Is the lawyer looking away because they're distracted by an email notification? Or are they deep in thought? This digital filter sanitizes the interaction, stripping away the raw, human data that can make or break a legal strategy. Think about the most sensitive cases, a domestic violence victim trying to get a restraining order, for example. In person, a lawyer can create a safe, confidential space. They can see if someone else is in the room just off camera coercing the client. They can offer a tissue, a glass of water, a moment of quiet solidarity that builds the trust necessary for the full, unvarnished truth to come out. Online, that client might be in the same house as their abuser, forced to whisper, unable to convey the true terror of their situation. The technology that promises connection can, in these moments, become a barrier to true understanding and a genuine threat to safety. Then there are the technological pitfalls themselves. We've all been on a glitchy video call. Now imagine that glitch happens right when the lawyer is explaining a critical deadline for filing a lawsuit, the statute of limitations. You miss it. You think you heard 2 years when they said 1 year. You wait, and just like that, you've lost your right to ever seek justice for your injury. The case is over before it even began, all because of a dropped packet of data. And what about security? Attorney-client privilege is one of the most sacred pillars of the American legal system. It ensures that you can speak freely to your lawyer without fear of your conversations being used against you. But what platform are you using? Is it end-to-end encrypted? Where are its servers located? Is it vulnerable to being hacked? A traditional law office is a physical fortress of confidentiality, with locked file cabinets and secure networks. A random app on your phone might be the digital equivalent of discussing your case on a park bench. You're trading a fortress for a tent, and you might not even realize how exposed you are. Perhaps the most insidious danger, however, is the illusion of expertise. Many online legal platforms are essentially marketplaces like an Amazon for lawyers. They present you with a grid of smiling faces, 5-star ratings, and impossibly low prices. But who are these lawyers really? Are they deeply experienced specialists in your specific niche problem, or are they generalists trying to pick up gig work from 3 states away? This is the jack of all trades, master of none problem, and it can be devastating. Let's imagine a man named Frank. Frank owns a small, specialized manufacturing business. He receives a cease and desist letter from a massive corporation, claiming his new product infringes on one of their patents. It's a complex, intimidating document full of legal jargon. Panicked, Frank goes online and finds a service that offers a 1-hour consultation with a business lawyer for a flat fee of $150. Seems like a bargain. He connects with a lawyer based 1,000 miles away. The lawyer is perfectly pleasant. He looks at the letter, does a quick search of the patent database, and gives Frank some generic advice. He says, "It looks like they have a case, you should probably comply, change your product, and avoid a costly lawsuit." The advice sounds reasonable. It's safe. Frank, trusting the expert, spends over $50,000 retooling his production line. 6 months later, at a local trade conference, he mentions his ordeal to a fellow business owner. She's horrified. She refers him to her attorney, a local intellectual property lawyer who specializes in patent litigation for small businesses. Frank, just for peace of mind, pays for a second opinion. This new lawyer pulls up the case file. Within 20 minutes, she identifies something the online lawyer completely missed: a critical prior art reference from an obscure academic journal published a decade ago, which invalidates a key claim in the corporation's patent. Furthermore, she knows the corporation's law firm. She knows their tactics. She knows they have a history of sending aggressive, bullying letters to small competitors, hoping they'll back down without a fight. She tells Frank, "You could have fought this. In fact, you likely would have won, or at the very least forced a very favorable settlement." Frank's heart sinks. In an attempt to save a few $100s on an initial consultation, he cost his business $50,000 and lost 6 months of market momentum. The online lawyer wasn't malicious. He was just ignorant. He didn't have the deep, specialized knowledge required. He gave advice that was safe for him but catastrophic for Frank. This isn't just about hyper-specific areas like patent law. It applies to family law, where understanding the specific tendencies of a local judge is paramount. It applies to real estate, where a single county-level regulation can derail a multi-million-dollar deal. It applies to criminal defense, where a lawyer's personal relationship with the district attorney's office can mean the difference between a plea bargain and a prison sentence. Law is not just a set of universal rules. It's a local practice, steeped in nuance, relationships, and unwritten procedures. An online platform, by its very nature, often strips away that crucial local context. Finally, we have to talk about the business model. That low-cost initial consultation is often a loss leader. It's the free sample at the grocery store. The goal isn't just to answer your question. It's to get you into their sales funnel. The initial advice might be vague or designed to make your problem seem more complex and frightening than it is, pushing you toward their more expensive services. Document preparation, monthly subscriptions, or full representation by their partner attorneys. It can feel less like a professional consultation and more like a high-pressure timeshare presentation. A traditional lawyer, by contrast, is often playing the long game. They build their reputation in the community. They want your repeat business, your referrals. Their incentive is to solve your problem efficiently and effectively, to build a lasting relationship. The online platform's incentive is often just to make the next sale. So when you weigh the convenience against these risks, the loss of human data, the technological vulnerabilities, the danger of the generalist, the lack of local knowledge, and the potentially predatory business models, the picture becomes much clearer. The question shifts from "is it worth it?" to "when is it worth it and for what?" Because despite all these serious, potentially life-altering drawbacks, there is a time and a place for this new digital frontier of law. The challenge for us isn't to reject it outright, but to understand how to navigate it wisely. It's about knowing how to separate the truly useful tools from the dangerous traps, and how to identify the specific circumstances where clicking for legal advice is a brilliant move, rather than a catastrophic mistake. So, how do you stand on that dividing line and consciously choose the brilliant move over the catastrophic mistake? How do you turn the vast, chaotic world of online legal services into a precision instrument that serves your specific needs, instead of a blunt weapon that causes more harm than good? It comes down to asking the right questions before you ever type your credit card number into a web form. It's a simple 3-part mental checklist you can run in 60 seconds, and it could save you thousands of dollars and immeasurable stress. Let's call it the clarity, consequence, and confidentiality test. First, clarity. Ask yourself this one brutally honest question. Am I seeking clarity on a general legal topic, or do I need a specific strategy for my unique problem? This is the fundamental divide we've been talking about. Think of it like this. Seeking clarity is like wanting to learn the rules of chess. You want to know how the pieces move, the names of the openings, the objective of the game. You can learn this from a book, a video, or a quick session with a chess coach. An online legal consultation is fantastic for this. What's the difference between an LLC and an S-Corp? What are the basic steps in the probate process? What does at-will employment generally mean in the US? These are clarity questions. You're gathering intelligence, but needing a strategy is entirely different. That's like sitting at the chessboard in the middle of a championship match, with the clock ticking, and asking a grandmaster, "What is my next move right now with these exact pieces on the board, against this specific opponent who I know has a tendency to play aggressively?" The answer to that question depends on everything. It's not general information. It is specific, high-stakes advice. My business partner is trying to push me out using a loophole in our operating agreement. What's my first move? I just got a letter from the IRS. What's the first thing I should do, and more importantly, not do? My ex-spouse is violating our custody agreement. What specific steps should I take this week? Those are strategy questions. Answering them requires a deep dive into your specific facts, your documents, your history. Treating a strategy question like a clarity question is the single biggest mistake people make. Second, consequence. You have to be a cold, calculating odds maker for your own life. On a scale of 1 to 10, what are the real-world consequences if you get this wrong? A 1 is, I got a $20 parking ticket and I think it's unfair. The consequence of losing is $20. The risk is incredibly low. This is a perfect scenario to explore a cheap online service. A 10 is, I'm being sued for something that could bankrupt my company, or I'm in a custody battle for my children, or I'm facing felony charges. The consequences are life-altering. They are catastrophic. The danger zone is the middle ground, the 4s, 5s, and 6s. I'm signing a new employment contract with a non-compete clause. I'm thinking of breaking a commercial lease. My new startup is getting its first round of investment. These situations feel manageable, but they are riddled with legal landmines. A poorly worded clause in that employment contract could hamstring your career for years. Breaking that lease incorrectly could lead to a lawsuit that costs 10 times what you hope to save. Messing up that investment round could destroy your company before it even starts. My rule of thumb? For any situation that you would rank as a 4 or higher on the consequence scale, the potential cost of bad or incomplete advice is exponentially greater than the few $100s you might save by cutting corners. The higher the stakes, the more you need a dedicated, traditional attorney-client relationship. And third, confidentiality. This is the simplest question, but perhaps the most critical. Are you about to discuss or share information that, if it were ever exposed, could be used against you in a court of law, in a business negotiation, or in your personal life? If the answer is even a remote maybe, you must stop and verify the security and privilege of the platform you're using. Remember, true attorney-client privilege is a sacred legal shield. It allows you to be completely honest with your lawyer without fear. But as we discussed, that shield can be fragile, or even non-existent on some online platforms. Are you communicating through a secure, encrypted portal? Have you read the terms of service to ensure your conversation is treated as a privileged communication, and not just customer data? Is the lawyer you're speaking with actually licensed in your state and acting as your lawyer, thereby creating that privileged relationship? If you have any doubt, you must assume you are speaking in a semi-public forum. For sensitive matters, assuming you're protected is not a strategy. It's a gamble you can't afford to take. Let's see this test in action with the tale of two entrepreneurs, Sarah and David. Both are starting new businesses. Sarah is launching a small, online bakery from her home. She runs the clarity, consequence, and confidentiality test. For clarity, she just needs to understand the basics. What are the pros and cons of an LLC versus a sole proprietorship for a one-person food business? It's a clarity question. For consequence, the stakes are low right now. She's pre-revenue, just trying to get the structure right. It's a 3 on the scale. For confidentiality, she's not discussing anything sensitive, just general business structures. An online consultation is a brilliant move for her. For $150, she has a 45-minute video call with a business lawyer who clearly explains her options. She gets the clarity she needs and confidently files for an LLC herself. She used the tool correctly. Now look at David. He's starting a tech company with a co-founder, but they're already arguing over who owns the core intellectual property. The code David wrote before they even partnered up. He's stressed and wants a quick answer, so he jumps on the cheapest legal subscription site he can find. He fails the test. He thinks he needs clarity, but what he really needs is a strategy to protect his ownership of that code in a contentious co-founder dispute. That's not a general question. For consequence, the stakes are massive. It's a 9 on the scale. The ownership of this IP will determine the entire future of his company and his personal wealth. For confidentiality, he uploads snippets of their early agreements and discusses the specifics of his co-founder's threats on a chat platform governed by a vague privacy policy. The lawyer on the other end, who is licensed 3 states away and doesn't specialize in IP law, gives him generic advice about partnership agreements. Based on this, David sends an aggressive email to his co-founder, which only escalates the situation and weakens his legal position. He made a catastrophic mistake. The platform wasn't inherently evil. David's application of it, in a situation that screamed for a dedicated specialized attorney, was the disaster. This brings us to the most important point of all. The rise of online legal services doesn't mean you need to become a legal expert. It means you need to become the CEO of your own legal problems. You are in charge. These online tools, the consultations, the form builders, the legal information websites are just that, tools in your toolkit. Your job as the CEO is to know which tool to use for which job. You use a screwdriver for a screw and a sledgehammer for demolition. You use a quick online consultation for clarity, and a dedicated law firm for a high-consequence strategic battle. The ultimate goal is not to avoid lawyers. It's to use them more intelligently and more efficiently. Think about it. You can use an affordable online consultation to get your bearings, to learn the basic vocabulary of your issue, to organize your documents, and to formulate the right questions. Then, when you do walk into a traditional lawyer's office for that high-stakes issue, you're not starting from zero. You're not paying them $200 an hour to explain the basics. You arrive prepared, informed, and ready to have a deeply strategic conversation. You have used technology to make the traditional legal process more effective and less expensive. So, is an online lawyer consultation worth it? The answer we've arrived at isn't a simple yes or no. The real answer is that it's entirely up to you. It's worth it if you are a disciplined, informed consumer who understands the tool's limitations. It's worth it if you are honest with yourself about the stakes of your situation. It's worth it if you run the clarity, consequence, and confidentiality test before you ever click book now. Your legal health is just as important as your physical or financial health. You wouldn't use a WebMD symptom checker to perform surgery on yourself, and you shouldn't use a generic online legal chat to navigate a life-altering lawsuit. The power in this new legal landscape is not with the websites or the algorithms. The power is with you, the user. It's the power to educate yourself, to assess your own needs, and to choose the right level of care for the right problem. In an age of instant answers, the smartest legal move you can make is often having the wisdom and the patience to know when to stop clicking and start building a real relationship with a trusted advisor.